freedom to operate your business. You want to be able to set your business up so that you can actually operate it. And that means two things. It means protecting against other people coming in and kind of siphoning off or sucking away parts, the market that you should be protecting. But then also knowing what's out there in the landscape so that you're not infringing somebody else's work that they're doing. So we've got a client, for example, who filed for a trademark for their marketing agency. And their marketing agency had been operating for a few years. It would have been a lot better if they had filed originally when they created the marketing agency, but they didn't. Fortunately, in the trademark world, you can file later because using it in commerce just builds the value of your brand. It doesn't prevent any filings on the trademark side. Patents are the opposite of that, by the way. But so they started a marketing agency. A few years later, they hired us. We said, hey, this is a great name. You've built a great company. You should really trademark this. So we went to file a trademark on it. Well, it turns out that there was another company, small company. They had filed a trademark application before my client did, right? They had filed one for almost the same name, a slightly different spelling, but in trademarks, that doesn't really usually matter, at least in the US. We had to navigate this discussion with the other owner to say, hey.
Hi, I'm Zarina, and welcome to the Grownlearn podcast. Beyond these conversations, I actively connect investors with high growth opportunities. Right now, I'm working on projects seeking strategic partners, like a $346 million real estate development, a revolutionary heating technology, and an AI-driven life insurance disruptor. If you're an investor, PE firm, or family office looking for scalable ventures, let's talk. Book a call at grownlearn.org to explore these opportunities. Today, we're helping entrepreneurs and startups with my guest, Jeff Holman. He's a fractional legal officer, business strategist. We're going to be speaking about business strategies for startups, how to deal with your intellectual property, how to register trademarks, and why this is useful specifically for startups. Hi, Jeff. Welcome.
Thank you, Zarina. It's a pleasure to be here.
My pleasure. Where do we start? Jeff? Tell me a bit about you. Let's talk about the person first.
Yeah, for sure.
Who's behind the mic?
Well, I'm a father first and foremost, husband. But
how many children do you have?
Oh man, I've got 4 kids, and 2 of them are still in the house, and 2 of them have moved out, and they're doing their own thing, and we're just glad when they can make it back to us.
Oh, fantastic.
Yes.
Okay.
So, so my career though has been based around, I started out with electrical engineering for a short time. Used to design hospitals, power and lighting for large buildings, stuff like that. Did a few fun projects with some very high-end homes and lighting design. But when I did engineering, I knew I always wanted to do something else. I thought I wanted to run a business or be in business. So I applied for a bunch of really nice MBA programs, and they all told me no, not yet. So I thought I'd take a few years and get back into the business. And in that time frame, I had a buddy who came to me and said, hey, have you ever thought about patent law? So the last that was in 2001. So the last almost 24 years have been this pathway down a legal career with a background in engineering that's really helped out on my work with inventors. And then later I did go get my MBA, so I kind of rounded that back out. And now I work for the last 10 years I've worked with startups really closely, just helping them maneuver all of the different pieces that they need to put into place for legal compliance and getting investors and getting their business running. So that's where I've spent the last 10 years of my career is working with startups directly.
Yeah. Talking about patent law, I recall I had a professor, also an MBA professor, teaching patent law, I believe, or strategy, I can't remember, but she wrote a book about patents. It's like a super thick book, which I have somewhere behind me, but it's a very complex matter. Why should startups consider this in the first place? I mean, that's probably not their priority to deal with patents, with registrations of intellectual property. Why would you say that's important?
Yeah, that's a It's a really good question and a really valid question because, we work with two types of businesses typically. And we either see the person who comes to us and says, I have this business and I'm starting to sell stuff and I'm just kind of going and running and making money. And they tend to be a little less focused on legal and on patents and trademarks. That's one type. The other type that we see a lot of, because we do a lot with patents, is we see a lot of people who are more inventors and they say, hey, I've got a product that I want to create. I've got this idea, I want to bring it to life. And the business side of it for them is a little less prominent, right? They're more concerned a lot of times about making the product than they are about selling it. And so, I think we sit in the middle of those two pretty well because we tend to bring a little bit more legal compliance to the sales guys, and we bring a little bit more business savvy to the inventors, and we try to get everybody so that your business is balanced out, right? I view it in the time I've been working with startups, I really view it as kind of this three-legged stool. You need to validate your product, make sure it works, right? That's kind of the inventor side of things. You need to validate the market, make sure that you can make the product at the right price and sell it to people and make money. That's the business side of it. And then the third stool, the third leg of that stool is what I call freedom to operate your business. You want to be able to set your business up so that you can actually operate it. And that means two things. It means protecting against other people coming in and kind of siphoning off or sucking away parts, the market that you should be protecting. Or it means maybe putting protection in place so that, well, let me say, I about repeated myself. Putting protection in place so people don't come in and take your market, but then also knowing what's out there in the landscape so that you're not infringing somebody else's work that they're doing, because that just as easily could shut your business down because of the damages that come along with infringing other people's IP. So freedom to operate is really that leg of the stool that I focus on with my customers. It's not more important though than the product, and it's not more important than the sales in the business, but it is an important component to go along with those two.
Yeah. Let's go back a bit to the basics and talk about the difference between patents and trademarks, who is affected by these concepts at all. And I also want to ask, maybe you can throw it also in the conversation of why in the age of mostly services and that there are not that many products developed, do we need to care about patents and trademarks?
Okay.
Can processes also be patented? Maybe we can talk a little bit about the different types of startups that can benefit from
Yeah.
yeah. Mm-hmm.
Yeah, for sure. There's kind of a surface layer that's really easy to go through, and then everyone's situation is specific, and there are lots of details. We won't necessarily get into those, but at a really high level, there are four types of intellectual property, right? There's patents, we've mentioned. There are trademarks, there's copyrights, and there's trade secrets. And then I have this other fifth category over here. I just call it contracts because contracts are the thing that we use to manage and transfer and negotiate all of the other four types of IP. Patents now, they protect something that is an invention. You've created a new structure, a new thing, a new piece of hardware, a new product, an e-commerce product perhaps. You've created a new thing, a new way that something functions, and that's what patents cover, utility patents specifically. Trademarks cover brand assets. So anything that you choose to brand your company, it could be the name, it could be the logo, it could be colors, sounds, whatever you choose to brand your company uniquely from other companies is considered a brand asset and something you can protect with trademarks. And then copyrights are the works of authorship, kind of creative works that people create. They write a story, they write an article, they write some music or lyrics or paint a picture. Those works of authorship, those are the things that are covered by copyrights. And then trade secrets are things that you keep secret for your business to drive value in your business. But there's a lot of overlap between these, right? Because you could see how something that's a creative work of authorship and protectable under copyrights could also be used as perhaps the graphical part of a logo for your business. So you could actually protect that with copyrights and separately protect it as a brand asset with trademarks. There's kind of some similar crossover with patents because most people think of utility patents, but there's also this other subsegment called design patents. And design patents, they protect the ornamental style of something. So you get a lot of things, products that have this trade dress to them, the way they look. And it may not be a specific branding element. This happens a lot in shoes and automotive industries. You look at the cars out there, you look at fashion or shoes in particular, and you see all the design elements that they have. Some of those design elements really clearly are the logo incorporated into the shoe. But other design elements aren't necessarily used for branding, but they're used as a unique design element that shoe creator or that automobile creator wants to keep for themselves and keep other people from copying. So while you've got the different types of IP, you've also got some overlap in there, and then you've got a lot of different layers that you can put into that. So how's that for an overview?
That's fantastic, but I have one. I want to dig a little bit deeper because I have a specific question for fellow colleagues, consultants for businesses. Say I have a specific process that I use to evaluate the strategic stage for, I don't know, for something in a company. And let's say I'm working on both M&A and strategy, and I'm entering a company and I have a specific process that is mine. I want to protect it. I'm not training people on it, but I'm using this specific process and I'm working with fellow experts that are also using this process. How can I protect this?
Yeah, so there are a couple ways to protect it. And I have these types of kick-off road mapping conversations with clients all the time. So if somebody comes to me and they say, hey, I've got this process, I want to protect it, we'll say, are you doing anything to implement that process through technology? Because if you want to patent it, it is possible to patent a process, but the process has to be implemented through technology and has to meet some other criteria. Essentially, you have to be doing something new that nobody has ever done before. You have to be doing something that's non-obvious, meaning it's not so close to what other people are already doing that it would just be an obvious, predictable change. There's got to be some element of unpredictability or unforeseeability to make it non-obvious. But then you also have to implement that process with technology. What that really means and what that comes down to a lot of times is we talk about these software patents. And software patents are harder to get usually than like just a product patent. But the software patents, what you're doing is you're taking data of some sort. Maybe you're taking a bunch of inputs and you're using maybe your market analysis numbers, typical standard numbers, and you've created a new algorithm, and that new algorithm creates a new index score, let's call it. And that score, nobody else has ever done that score before. And it's a little different than the types of scores that people use. And because you've created an algorithm that creates a new score, and that new score has a purpose that you've created for that score, there's a possibility that you could protect the implementation of that process in a software environment. So that's one way. That might not sound very straightforward because sometimes it's not, but you have to get the process. You have to think kind of like outside of what normal business people would do and say, how would I actually implement this? Who would I call? What maybe dev team would I call to implement this? What would they need to do it on? It's going to be implemented via computers somehow, I suppose. And then we have to take it on the patent side and we have to make it look unrecognizable, unfortunately. We have to say, well, the algorithm is going to be stored on a memory device and it's going to be processed and, the calculations are going to be done by a processor. So we have to fit all those process pieces that you come up with into a computer system in general. And so getting that's what it would take to get a software patent on a new process with either new data or old data that's manipulated in a new way. The other thing that I would tell clients is if you're doing a new process, you're going to all the effort to create this process. Are you taking advantage of the opportunity to create some type of branding around that process, right? And it might be as simple as maybe there's a new name for the process, right? Maybe there's a new name for the outcome, the number that's generated, that index number. Maybe you give that a name. Whatever it is, you're putting all the effort into creating this process, educating the market about this process. It's not much more of a step to then add some branding elements to that and perhaps get a federal registration for the trademark that you're using to brand that new process. And those are the two things that we typically see companies use. A third element that you might see for IP protection in this case is the data set that you've got, right? What is the data set that you've created? Is it your own data? And do you have some type of unique access to data that is controlled and maybe secret in a way, and only you have access, or only you have access to the way that you're taking that data in and manipulating it? That might form a trade secret. And so now you have perhaps a third layer of intellectual property just on that one process.
Mhm. You mentioned registration of a trademark with the federal authorities. I know there are different types of offices, regional, country offices. On what level do you operate, and how can you help companies that are willing to expand internationally, for example, or across several states?
Yeah, that's a great question. There are all of this stuff that we're talking about is really, whether it's patents, trademarks, copyrights, whatever, it's all jurisdictional, right? So what you're in Europe, and the things that happen in Europe, or even the things that happen in a specific country in Europe sometimes are different than the things that happen in the United States, or maybe even another country in Europe. So everything is jurisdictional. You need to really look at where you need your protection, based on the customers that you have, or where you're developing your product, or where you're shipping products through, perhaps. All of those things are important. So how we help people is that there are a lot of, for all of these types of IP, pretty much, there are agreements and treaties that countries have entered into so that one country might recognize the work that's been done towards a patent or a trademark in another country. And so here in the United States, I'm based in Utah, and we work with people from all over the United States and also outside the United States to get trademarks registered here in the United States. When we have a client who's in the United States and they want to get a trademark somewhere else, we then work with local legal counsel in those countries to get something registered. So for example, we've got clients who want to ship their products over to, they're selling in Amazon in the United States, or they're selling on a Shopify account. They want to get their products over into Europe. And so they want to start selling there, and they want to try to protect their same trademark in Europe that they do in the United States. So you can apply for something called a community trademark there in Europe. You can also get protection in individual countries if you prefer. You can go through something called the Madrid Protocol, which is really an agreement, an intercompany or intercountry agreement, where they recognize the priority that if you file here in the United States first, then you can file later in another country. And as long as you meet the criteria, those other countries will say, well, under the Madrid Protocol, we recognize that the first filing you did in the United States acts as priority, even though it's here in Europe, for example. So there's a lot of, the patents have their own ones, the copyrights have their own ones. So there are a lot of treaties and international agreements that, depending on which country you're in and which country you're trying to get protection in, you can typically find a way to connect those together and preserve the priority of your original filing in the first country.
Mm-hmm. Are there any stories of mishaps if startups have missed registering a trademark or a patent, and after failing with this, they've come to you and you've come to know about their story?
Yes, yeah, there are really. So we see failures in two ways. One is, I'll just tell you real generally quickly. One is that a lot of people try to DIY their own trademarks and patents. And I'm actually an advocate of doing it, but if you do some of those things wrong, you can't really fix them. You just lose 6 or 12 months of time, and you have to come back. So we have a lot of clients who come to us. They say, I tried this. I got, 9 months later, I got an office action, and they said I filed in the wrong class, or I filed the wrong type of mark, or something really simple that we would have known how to do right, but they just didn't. And so they'll come to us, and they've lost those 9 or 12 months, and so we'll refile it for them. But maybe more directly to your point, what we've seen a lot of times, we've got a client, for example, who filed for a trademark for their marketing agency. And their marketing agency had been operating for a few years. It would have been a lot better if they had filed originally when they created the marketing agency, but they didn't. Fortunately, in the trademark world, you can file later because using it in commerce just builds the value of your brand. It doesn't prevent any filings on the trademark side. Patents are the opposite of that, by the way. But so they started a marketing agency. A few years later, they hired us. We said, "Hey, this is a great name. You've built a great company. You should really trademark this." So we went to file a trademark on it. Well, it turns out that there was another company, small company, and I can't remember where they're located. Maybe it was Canada or somewhere out of England. I can't remember exactly. But it turns out they had filed a trademark application before my client did, right? They had filed one for almost the same name, a slightly different spelling, but in trademarks that doesn't really usually matter, at least in the US. And so we had to go through and we had to navigate this discussion with the other owner to say, "Hey, we actually filed after you. That's clear. But we've existed since before you, and we've established this brand." And the other company was really kind of standoffish, right? They said, "Well, I'm not going to work with you guys." And we said, "No, you probably are because of the sequence of how things worked out, we could probably get your mark canceled, right? And so we could file with the US Patent and Trademark Office and petition them to cancel your mark. We don't really want to do that. It would be easier and better for everybody if we just agreed to concurrent use of the marks. You keep using your mark, we'll use our mark, and we'll both agree that it's okay for the other person to use their marks in their regions or in their industries, because usually there can't be a direct conflict, but there's oftentimes like kind of we're kind of in the same market, but kind of not. We're kind of in the same area, kind of selling to the same clients, but kind of not. So we had to negotiate this, and fortunately, my client, despite filing much later, had a pretty strong case to say that they could, if they wanted to, cancel that other person's mark. And so that was convincing to the other person to say, "Well, okay, let's come to an agreement." It's called a concurrent use agreement. And once we did that, our client was able to get their trademark registered in the US, showing that despite that other mark's existence, everybody was in agreement that this wouldn't create a problem. And so the US Patent and Trademark Office let the mark get registered. So
Yeah.
sometimes there's negotiations like that, and it's not just straightforward, right? Because people have created businesses, they've picked a name that they really love without doing any real due diligence or searching, and they're adamant that that's what they want to launch their business under, and that sometimes will create obstacles, or we'll find that there are obstacles in the way as we proceed down that path with them.
Very interesting. I wasn't aware of this concurrent option that you can
Yeah.
use trademark simultaneously. Quick break. If you're looking for high growth opportunities or expert strategy support, let's talk. I'm involved in projects like a next-gen biofertilizer transforming agriculture, an aerial mapping drone that's 10 times faster than traditional tech, and AI-driven innovations disrupting industries. As a fractional chief strategy officer, I help businesses execute strategies and bring in top experts to get things done. Let's discuss your needs. Book a call at grownlearn.org. When it comes to international usage of trademarks, say there's a person in China who claims the same trademark and I operate internationally. Are they able to file concurrently for the same usage of trademarks?
It depends on it. They would probably only do that if there's a conflict. So in this scenario, I'd say, well, what are the facts that are happening? Are we trying to enter into China, and is my client moving into China and there's already an existing Chinese trademark?
Well, let's say it's a Chinese company.
Yeah. We run into a lot of Chinese trademarks because when we work with e-commerce companies, they're often producing their product in China. At least right now, we'll see what the tariffs here in the United States do to that.
Yeah.
And so what we find is Chinese trademarks are important, perhaps for a slightly different reason. In China, sometimes you find business partners who aren't very good business partners, right? You find a trading company or maybe perhaps a manufacturer who will say that they own your mark, and maybe they filed for your mark in China because you didn't. Maybe there is legitimately somebody who has that mark, or maybe it's a scam, or sometimes there are these scams where Chinese companies say, "Oh, someone's trying to register your mark, but we'll file it for you first so that they don't get it." But that's really just a scam to try to get you to spend money with them. So what we find in China is that sometimes the people who you think are your business partners are undermining the business relationship, and they're filing in China a trademark on your trademark so
Mm-hmm.
that they can then hold you hostage,
Yeah.
essentially,
Wow.
and
Mm-hmm.
not let you manufacture. If you try to ever move your manufacturing to somebody else, they'll say, nope, sorry, we own the mark here. Nobody
Yeah.
else can manufacture your product here. And so trademarks are
What a
important, but
scheme. Incredible. I've
yeah,
never thought about this. Yeah.
well, until you see it, yeah,
Yeah.
there are a lot of very creative people out there finding
Mm.
ways to make themselves money. But that's why I said before, you got the four types of intellectual property, and then you've got contracts. And so the contracts that you enter into in China with Chinese manufacturers and other representatives in China become extremely important because that's where we would put restrictions in place. Hey, we want to work with you, but you don't have the right to trademark our brand, right? You can't use our brand or our product. You can't disclose it to other people. You can't circumvent us in the relationship, things like that. So you need to know that in China, if that's where you're going, that you need to have this in an agreement in place, and it's as important or perhaps more important than the trademarks themselves. You still want the trademarks, but sometimes the agreements are what drive the relationship way more than the marks themselves.
Mm. Very interesting. It raises like various questions, like what is the arbitrage court, for example, where you would resolve resolutions when it comes to China? And I don't know, lots of questions.
No,
But
those are
yeah.
great questions because there are some very specific arbitration courts in China. But if I'm in the United States or I'm somewhere else and I'm entering into a contract in China, you have to think, where can I actually enforce this agreement? If all of my products are being made in China, I probably have to go to China to enforce it. Well, if I have to
Mm.
go to China but I say it's based on Utah laws, or it's only in English, you really need to have a Chinese version of the agreement. You need to have it based on Chinese laws and enforceable in China, even though normally I would prefer that it's, enforceable in where I'm at, not where my other party's at. So there are a lot of things that go into negotiating that, including arbitration courts, like you mentioned.
Yeah, well, I can see how startups definitely would need a service like yours, specifically if they're producing in China or, all the other types of
Yeah.
startups that you're serving. You mentioned that there are five strategies for startups that you could share with us. I can't really remember
Yeah.
what it was about. Hmm.
Yeah, so I have a definition for strategy that I've come up with because I've heard a lot of other people talk about strategy, and there are a lot of people who say, oh, strategy, there's these parts to it, but they never quite fit together. So perhaps because of my engineering background, I thought, how do we define this in a way that really is easier to understand? So what I did is I came up with a definition that has five parts to it. And it's pretty straightforward, although each part has quite a bit of depth to it if you wanted to explore it. Here's how I define strategy. Strategy is number one, a plan. You got to have a plan, right? That's probably the most basic part. Strategy is a plan to deploy valuable resources, and those could be intellectual property assets. That could be your team. That could be money that you have, access to a network. So a plan to deploy valuable resources for a sustainable advantage. I think that's where most people focus strategy. Sustainable competitive advantage. So we could talk about what that means. So a plan to deploy valuable resources for a sustainable advantage toward a business leadership objective. And this is the one I think most people miss, that, business leadership objective really means, are you trying to be the cost leader or are you trying to be the market leader? Are you trying to drive down your price, your costs so you can pretty much undercut everybody else while maintaining a profit? And there's only position for one of those people in the market, right? There's only position for one Walmart that's lower cost than everybody else, but still makes money. Or are you trying to be a market leader? And that's the Apples of the world. You're developing a brand where people will pay a premium for your brand because they like your brand. They probably love your product, but they also love your brand, and that's where the premium comes in. So it's a plan to deploy valuable resources for a sustainable advantage toward a business leadership position in a competitive environment. And we could talk about, the competitive environment might be pretty clear, but that's where a lot of my clients focus a lot of time because they don't want to go up against these behemoth global Fortune 500 companies and say, hey, we're competing against IBM. That wouldn't work. So what they do is they pick a very narrow niche, a very clearly defined target market, and they say, this is our competitive environment, and we're going to be the top company, either from a cost basis or a market leadership perspective. We're going to be the top company with this some small slice. That might be where they start. The hope is that they grow into new markets, new products, things like that over time. But that's how most startups really need to start is picking the market and the ideal customer profile that they're going after and deciding, okay, are we more about our cost structure or our premium branding? And from there, then you can start to really define what assets do I need to either create or control or buy or have so that I can achieve the business leadership objective in the market that I want. And then how do I position myself so that's sustainable, at least for some time, so that I can keep people out or I can keep ahead of the people that are behind me. And once you have all that, you just put it into a plan. It sounds easy, right? Well, just, okay, that's what we're going to, over the next 12 months, we're going to achieve these things and we'll be this, this type of leader in this type of market. So,
well, lots of companies are now competing with new business model, a hybrid option. It's neither market nor it's neither cost advantage nor
brand leadership.
differentiation. Yeah. So I can't think of any example right now, but I know I've actually gone through cases, and I know there are companies that do both.
I agree with you that
Mhm.
yeah, the markets are big, right? Like we say there's only room for one cost leader, and in every like specifically defined market, by definition, that's true. But there's a lot of depth to markets, and so if a good example, I think, for what you're saying, is if you look at the legal industry right now, the legal industry, any attorney can go out and they can start their own law firm and they can start picking up clients. And there are enough clients out there that they're going to be able to pick up clients and run a business. Now, whether or not there's any strategic positioning to that or not is probably what I would debate, right? You can start a company, you can run a company, you can make money, you can probably have a good lifestyle business, maybe even a very successful business. But there's a lot of there are a lot of businesses out there, a lot of small to medium businesses that really start and operate and never actually have a strategy. And that's okay if that fits what they're, if the owners in those businesses, the employees in those businesses are meeting their own objectives, then great. But I think if you really want to be strategic, and again, back to the idea that if you're building a company, you might as well build a brand with that company. And if you're building a company, you might as well, if you want, add a strategic layer to your company so that you're not just building any company that might be knocked off by, changes in economic markets, or perhaps, somebody else moves in next door and you have no competitive advantage. You don't have any distinguishing features about your business, and you just lose market share because you're the same as the other guys that have entered the market. There's a lot of room for that. I don't, is that an example of what you meant, or were you referring to something else?
Yeah, it could be, yes. It's your answer, so it's a good example. So my next question is then, is your company, being a fractional legal officer, your differentiation in this market?
Yeah, it is. And it's, I am always trying to work on that and make our position better. But we're the only company out there that I found that does a fractional legal team. What's interesting is law firms generally could probably replicate what we're doing pretty easily because they have a lot of the people in them that could do, what we do is we bring essentially a fully staffed small in-house legal team to businesses on a fractional basis. They typically pay us a monthly fee, depending on how much they need our services, but they get access to our entire team as if we were, down the hallway from them. They can poke their head in my door or give me a call and say, hey, I got a quick question for you. Or I've got a question about patents for Ross, or I've got a question about, we got a cease and desist letter. So it's this very collaborative, open, integrated approach to practicing law. Most law firms have the skill sets that they could cover the same things we do. What they're missing, though, is they're missing a business model that facilitates a collaborative approach. Because when you go to a law firm, you'll find partners who gatekeep clients and associates. They want everything to funnel through them because their business model is set up so that's how their compensation works.
Yeah.
And so some of the internal structuring that they've done is really a limitation that will make it so they'll never adopt our model because our
Mhm.
model is way too progressive, I think, for a lot of traditional law firms. They could
Mhm.
do it. And so what we're working on doing on our end is building up the brand around our fractional legal team. I don't know anyone who else who uses that term. I used to call it an integrated legal counsel because I think that's more descriptive of what we do. We want to integrate with our client teams. But as we noticed the last couple of years, the fractional terminology has really been adopted very widely, inside and outside of the legal industry. And so we've adopted our messaging and our what we call ourselves to that so that we can essentially be the first fractional legal team and maybe the only fractional legal team that I'm aware of in the market today. So, we're like any other business, any other entrepreneurs, like a lot of our clients, we're constantly working on our own models, our own messaging, our own positioning, and our own strategy.
Mhm. How large are your clients? Because you mentioned startups, entrepreneurs, but it seems like if you're bringing a team of, let's say, 5 legal experts, it seems we're talking about a much larger startup, at least at a different stage. It's not
Yeah,
really
we,
a startup at the
yeah,
beginning.
that's a fair question. A lot of times, our ideal clients, where they'll find us is when they say to them, there's two things that happen. One, they might be looking for their first full-time legal hire, right? They say, hey, we just need somebody who can really watch our interests. They can be part of our team. And so our services are about the same price as what somebody would run into if they're hiring their first full-time legal hire. What you get with our service, though, is you get 5 different attorneys with specialties that cover pretty much everything you need. Whereas when you hire a single attorney, you get their one specialty or their two specialties, and
Yeah,
you
you still have to hire an external team to help him.
exactly,
Yeah.
exactly. And so our team comes on board for about the same competitive cost to hiring that one attorney. So that's the one stage that is pretty popular. And I think very related to that is those companies, even if they're not looking to hire their first in-house legal counsel, those same companies, they run into essentially a backlog of legal issues that have been sitting and kind of festering for a while. And they say, well, I really should have done this, or I promised a couple employees that I would do these things, or I took some money from an investor and I never really wrote down all the documents like I probably should have. And so they build up this backlog of legal issues that they're kind of overwhelmed with. They're tired of avoiding them. And so they finally say to themselves, I just need to bring somebody in who can clear this out, clean out my closet, so to speak,
Mhm.
and help us start fresh. And so sometimes those are the exact same companies that say to themselves, we need to hire our first full-time legal hire. Other times, those companies haven't gotten there, and they're trying to find, well, who's the guy that can clean up this investor issue? The lady that can clean up this patent issue? And I get it. Nobody wants to go and hire an attorney. Nobody wants to go hire 4 or 5 attorneys to clean up the problems that they've got, right? And so we really try to be a single point of hire with a single point of, a single team approach so that you hire us once, we can really step in and do the full scope of what somebody needs to not only clean up, but then plan for the growth and the scaling that's ahead of them.
Mhm. Sounds fantastic. One last question about how exactly you work. You're based in Utah. Where are your clients based? Do you go physically? Do you work online? How does it work with your
With our fractional legal team.
and what I mean is with the permissions. I know that you're allowed to
Yeah.
practice law in certain states. I'm not quite sure, but I would suppose because that's the way it is in Europe.
Yes, it's a very good question. So here in the United States, we have state bars, and so we're admitted into our own state bars. And somebody might be admitted into multiple. In my case, I'm admitted in Utah and California, and we have a couple of attorneys on our team who are admitted in other states. So there's the individual states where we're located and where our clients are located. If they're located in our state that we're already admitted to, we can practice for them no problem. The other thing that happens, and it's a kind of a different layer on top of the state bar admissions, is you have things like the U.S. Patent and Trademark Office, which has its own bar and is a federal practice. So people can, if they're part of the part of the patent bar, they can practice federally. They're not limited to certain states where they can practice or where their clients are. So anything that's patent related, we get patent people coming to us from across the United States, as well as several people from Australia, New Zealand, some people from Asia. So we get work coming from everywhere because that's a federally based practice. We don't have to worry about our individual state licensures. Trademarks are pretty much the same way, federal trademarks. And then there's some other practice areas that we don't typically get into, like bankruptcy. There are some tax things that are federal practices. So it's a great question. The short answer is this: our clients, if we're not doing something that's federally based, then we're limited to where our clients can be located. We have to have some type of what we call nexus with our clients in order to practice for them if they are not located in a state where we have licensure. And so a lot of our clients, they come to us because they want, they're starting that business, they're innovators, they want that patent, they want that trademark. So our initial interactions with them are very much federally based. And then when they say, well, we're going to start doing a little bit more work around other things, then we have to evaluate, do we have an admission that allows us to do that, or do we have some other nexus that allows us to keep working with them? Certainly, we can't go into a different state. I'm not licensed in New York, for example. I can't go to New York, show up at the courts and say, I'd like to represent my client in a New York court. Now, there's one last layer to it, and this might be getting too deep, but there's something where you can get admitted on a temporary basis in front of a court. It's called pro hoc vice. And so sometimes our clients, we had a client recently, they're out of Canada. They have a patent that was that they applied for, or a trademark that they applied for, on a product that they were working on with a company out of Taiwan who was manufacturing in China, and some things happened with that relationship. It wasn't going well, and one of the companies sued the other company in Virginia. We're not licensed in Virginia, so what we do is we do two things. We find a Virginia attorney and we collaborate with them. But in that case, and in some other cases, we'll actually also get ourselves admitted just for that limited, scenario for our client to talk with the courts directly, in addition to working with the attorneys who are there. So it becomes kind of a complicated puzzle to make sure.
Yeah, but that's more for the conflict resolution rather than for the registration and for the filing, right?
The registration and filing things. Yes, for the filings, like in the courts, certainly, we don't typically do those if we're not registered. So we would have to be admitted. And even then, we like to have local counsel. But when it comes to negotiating a settlement between the parties, we will typically handle that directly.
Mm-hmm.
So
very interesting conversation. I actually learned a lot, and I enjoyed it. I enjoy learning about, all of the things that I've never delved into. So definitely an interesting topic.
very good.
Yes. Where can people get a hold of you? What's your website called?
So my website is intellectualstrategies.com. It's kind of a play on intellectual property strategy. So intellectualstrategies.com. And if we've got people who want to jump on a free 30-minute kind of planning call, talk about what they've done, maybe what problems they're dealing with, or what types of patents or trademarks they're trying to work on, I'm happy to have a free consultation call with people to explore those things with them, get them pointed in the right direction at least. And they can find a link really easily from my website, just to see my calendar and book a call there.
Fantastic. Thank you so much. I enjoyed our talk. It was very informative. Thank you.
Thank you, Zarina. It was great being with you.
Thank you for listening to Grow and Learn. We hope that you found our podcast informative, engaging, and inspiring. Our mission is to help you keep growing and learning, and we hope that our conversations and insights have provided you with practical advice and useful perspectives. If you're looking for personalized support and guidance to help you achieve your personal or professional growth objectives, I offer a range of services to help. As a trusted management partner and mentor, I work with businesses in the process of transformation, looking for new streams of business, as well as M&A. With an extensive professional network of experts and mentors, I can bring on board the right person or team based on the specific needs of the company I'm working with. To learn more about the services I offer and how I can help you achieve your goals, please visit my website at grownlearn.org. You can also reach out to me via email or social media. I'd love to hear from you. And if you enjoyed this episode of Grow and Learn, please subscribe to our podcast and leave us a review. Your feedback is important to us and it helps us to continue to create content that is relevant and valuable to our listeners. Thanks again for listening, and we look forward to sharing more insights and perspectives with you in the future.